Okay, so today we're going to start with what is the complaints process. And as part of why you may be attending this presentation, I sometimes wonder if memberships, and not just this college, but many colleges, know that the complaints process exists and perhaps how frequent it is. So just to give the attendees an example, so from our annual report, which is where all of the college's statistics, financial information, etc., is available, and that is under our annual report tab on our website. In the last few years, so 2021, 2020, 2019, and 2018, there's a variety between 3 to 8 complaints a year. So mindful of our membership numbers on a total, there are complaints incoming in this process, and it really depends on the year and of course the nature of concerns raised. But this is all to say that our process does exist and complaints are made within it. Next slide, please. Thank you, Mackenzie. So let's start with where the complaints process comes from. So maybe before I dive in, and I don't know if you have an ability to raise your hand or you can put it in the chat, but who here is familiar with the Health Professions Act and Part 4 of the Health Professions Act? And I don't know if you have that ability, so I might just move on. But just to remind you, oh, and perfect. Yeah, I see one hand. So thank you. So, and sorry, Mackenzie, you can click through. Thank you. So the Health Professions Act is the guidebook or the piece of legislation relevant to the complaints process. So I often call it a guidebook, as in it doesn't have all the answers, but it does have the process of a complaint for a complaints director, such as myself, and a college to follow. So that would be from how a complaint can be made, what's required for a complaint to be made, what happens, what's the first decision when a complaint is made, continuing through the steps of what a complaint, the life of a complaint can be, which we're going to review together today. And the outcomes that are available potentially for a complaint. So I describe this as there are prescribed obligations, duties, and processes within Part 4 of the Health Professions Act that relate to, like I said, the complaints director, the college, a regulated member, and the participants in this process. Importantly, of course, these are processes that must be followed. There are certain things that are not optional. There are certain things that may be optional, but there are other things that are required of certain participants at certain different stages. Another thing that the Health Professions Act as a guidebook provides are the rights and responsibilities of a regulated member. So we're going to be reviewing those together briefly today, but there are some requirements on regulated members that are not optional, or they are consequences potentially could flow if they're not complete or that obligation is not followed. For example, on an employer or a regulated member, either one. Finally, as I indicated, there are certain decisions that need to be made. So after a complaint is received within this process, there are certain steps that a complaints director must take and within a certain amount of time. So those also are within this guidebook. Next slide, please. So briefly to review the participants in this process. So as I indicated, I am the complaints director, and there are many complaints directors. There's one at every single college for all of the professions. And the complaints director is an appointed statutory decision maker throughout this process. Next, there is a hearings director who Mackenzie, who's assisting today, is in the role of. And a hearings director role is to be similar to kind of a point person between what is the hearing tribunal or a decision-making panel of persons and what are the other participants, such as regulated member and complaints director. It's important to know that the complaints director can't be the hearings director and also can't be on a hearing tribunal, in the sense that these roles are defined within the Health Professions Act, the guidebook, to ensure that certain fairness exists and certain rights exist, and also certain people are not being both an investigator potentially and a decision maker, and then ultimately on the tribunal. So there's a reason for these roles being separated out. On the bottom, you see a regulated member or investigated person. So there are different ways within the Health Professions Act. A practitioner such as an SLP or audiologist may be referred to. It is an investigated person after an investigation occurs, which we'll be talking more about. I generally say regulated member just as the blanket title, being regulated by a college, but ultimately they do have a role and they are a participant in this process if they are facing a complaint. Next, on the top right, we see a complaint review committee. So this is another statutory decision-making body or panel to make decisions on reviews of dismissals. We will be talking a little bit more about dismissals, but they are an important participant in this process. Next, of course, we talked about hearing tribunal as an important decision maker. So tribunals would be 50% practitioners, SLPs or audiologists, and 50% members of the public appointed by the provincial government. And finally, there is the complainant, who is an important person in the process in the sense that they make the complaint, they bring the complaint forward to the college, and there are certain rights afforded to them throughout the process as well, similar to a regulated member, where appropriate, but they are enshrined and defined in the Health Professions Act. Next slide, please. Okay, so ultimately, the goal or the heart of the complaints process, part 4 of the HPA, is the receipt and determination of complaints of unprofessional conduct, including investigations. So this is a process that is triggered upon the receipt of a complaint of unprofessional conduct. And that process, that heart of it, is the formal processes on how to address it, potentially how to resolve it, how to hear the concerns that are raised, or potentially how to dismiss the concerns that are raised. There are numerous outcomes possible for a complaint, but the process itself of receiving a complaint is important because once that complaint is made, the process is initiated. Grounding this process is the college's mandate. So ACSLPA, like other colleges in Alberta, is a regulatory college. Our role is to regulate the professions that we are privileged to regulate. It's self-regulation is a very privileged process, and our mandate is the protection of the public. Ensuring competent, safe, and ethical practices of regulated member is part of that mandate. But in other words, we're distinguishable, and the complaints process is distinguishable than what could be a union, what could be an association, what could be other processes outside of the regulatory process. But the college's complaints process is grounded in our mandate as a regulatory college of protection of the public. Next slide, please. So as we discussed a little bit earlier, this is triggered about a concern or a complaint of unprofessional conduct. So it's important to know generally what are the categories of unprofessional conduct. So reminding of the disclaimers, of course, this isn't meant to be legal advice and not saying there's a, I'm not going to be giving a laundry list of examples such as like a documentation error or an assessment error, but these are the general categories defined in the Health Professions Act that every practitioner should be aware of. It's not exhaustive. The list is quite long. There's many failures to do certain activities, but these are what I would describe the general or the main categories of unprofessional conduct that relate to our process. So first would be the lack of skill, judgment, and knowledge in the provision of professional services. So how that would be worded, and I often find it helpful for members of the public or regulated members to give an example. So an example of a lack of skill, judgment, or knowledge could be on May 31st, 2023, Jane Doe failed to adequately document a patient incident or a patient involvement, demonstrating a lack of skill, judgment, or knowledge in the provision of professional services as an example. Similarly, a contravention of the Health Professions Act Code of Ethics or Standards of Practice could equally be worded very similar. So for example, if it's an allegation of disrespectful communication based on the standards of practice surrounding patient-centered care or client-centered care, honesty, integrity, respect, that could be equally worded as on May 31st, 2023, Jane Doe failed to respectfully communicate with client 1 about whatever they're discussing in contravention of standard practice. Insert numbers here. The next category could be representing themselves as having a permit while being suspended, canceled, or bound by conditions. So an example of this would be, let's say someone, and this is again just an example, someone went and applied for a new job while they were suspended, they were canceled, they had conditions and requirements, and they didn't provide honesty, or they didn't represent themselves as having those conditions. That could equally be unprofessional conduct. And then, as I mentioned earlier, failure or refusing to cooperate with college requirements. So we're going to talk a little bit more about the obligations on a regulated member, but examples of this could be failing to comply with a continuing competence program, failing to cooperate with an investigator, potentially failing to cooperate with other directions, etc., or requests from a college, mindful that a regulated member is regulated by the college and there is an obligation to comply, cooperate, respond, etc., to that college. And then finally, conduct that harms the integrity of the profession. So this is a little bit of a broader category, but where the integrity of whatever profession is being examined, it may be harmed. There are many examples in this. Examples that some may discuss would be things such as potentially social media, statements about the profession, potentially conduct that's not completed well on duty of the profession. So it's not in a patient or client appointment, but maybe it relates to something else, such as criminal charges, etc. This again is a broad category, and these are just some examples that could be applicable within this section. Next slide, please. Of course, you all will likely be very familiar with these definitions of sexual abuse and sexual misconduct. These are also defined in the Health Professions Act as specific types of unprofessional conduct due to the egregiousness and the concern to the mandated protection of the public and protection of patients or clients. I'm not going to review these definitions in depth because I know education is required on them. There is more information on our website about the applicable standards of practice, being mindful of boundaries, as well as understanding these definitions available for you if you are interested. But of course, they are very important to know within the context of unprofessional conduct, as well as the complaints process. Next slide, please. Okay, so now we have a grounding. The focus of the complaints process is, of course, as part of our regulatory pillars, protection of the public. It's guided by the Health Professions Act, the participants being the complaints director, potentially a regulated member, of course, a complainant. There could be other decision makers. There's also a hearings director in this process. Now let's talk a little bit about the life of a complaint, or what could happen. Next slide, please. So the first question I often receive is, who may make a complaint? Who can make a complaint to the college or any college? And ultimately, they can be submitted by anybody, but they're generally submitted by a current or past client or patient, a family member, a parent, a friend, or a guardian of a client or a patient, a colleague, a coworker, other regulated healthcare professional, a member of the public, or potentially as well, based on obligations, an employer. So these are all frequent interactors with a regulated member. It is a large category, but this is all to say that there's no obligation that a complaint only comes from a patient. Often, of course, clients can be underage as well, so it's very likely it could come from their parent or guardian. It's also not that colleagues cannot make a complaint about someone else, and those are some important things to remember if a regulated member receives a complaint, that there is no, in the HPA, it doesn't say this person cannot make a complaint about somebody else. Next slide, please. So how are complaints made? Practically, a complaint is made either in writing through a written letter, but most generally it's made through a complaint form, which has been recently updated in the last year or so. It is available on our website if you want to see what it looks like, what information is gathered within the complaint. And it has to be signed by a complainant, as well as the name of a complainant is provided to that regulated member generally, so they know who made the complaint against them. The complaint form collects information such as location, the relationship, other information about what happened. It may include supporting documents, etc. And it is, like I said, found on our website. Next slide, please. Thank you. So what information is on our website publicly available are frequently asked questions about submitting a complaint. So again, this ranges, this is just one example about who can submit a complaint and what can we accept about a regulated member, which we'll get into in a second. But there's other information if you are interested in the FAQs about it being signed, about a parent making it, about it not costing anything to make a complaint, about making a complaint, perhaps that there was a group concern, it was more than one practitioner, how to make complaints against multiple people, that this is not about an organization, this is not about, for example, an entire agency, it's about one practitioner, and more information on kind of what that would look like. And that's available to potential complainants, but it's also available to regulated members for their education, if there is interest. Just on the screen and very briefly, the FAQ that is on this slide is focusing on who can have a complaint made against them, and what the HPA or the Health Professions Act says is if they're regulated members or if they're former regulated members for up to 2 years after they were registered. So this would potentially be an example, and this is the most frequent example that comes to mind, is that potentially if an incident occurs in the workplace, whatever may happen, and that person immediately goes and cancels their registration the next day, of course, a complaint still could potentially be made about them for up to 2 years, in the sense that you cannot just cancel your registration to potentially avoid a complaint. There is definitions of time within the legislation and parameters around that. So of course, it would be optional in my mind if somebody wishes to do that, but just to know that a complaint could be made against a regulated member for up to 2 years. Next slide, please. Okay, so now let's talk a little bit. I know I said I was going to talk about the process. So a complaint is made, we have a form, it's filled out based on our website, a complainant has filled it out. There now has been a receipt of a complaint. So the main categories that are defined in the Health Professions Act, or the points of time that are made after certain decisions, could be an investigation, which we're going to talk about. It could be a hearing, which we're going to talk about, as well as it could be dismissal or resolution, which are on the right side of the screen here. And then finally, this is not as in trend in the Health Professions Act, but it is a part of the process that I believe is so important, is the compliance of the complaint. So this would be an example, and we will talk about this, of, let's say a complaint does go to a hearing, there is a finding of unprofessional conduct, someone is asked to do something such as supervision in the workplace, completing coursework, paying a fine, completing a suspension, whatever may occur. That compliance, or completing the things that have been asked of the regulated member, are also very important to the complaints process to ensure that the process is complete and the matter is closed and the requirements are met. Understandably, of course, if someone goes to a hearing or goes to a resolution agreement and says, yes, I will do a course, or let's just use an example as a course, I will do a course on X, and then they never actually complete it, of course, that compliance of the complaint and the requirement that was sought from the regulated member would never have been completed, and that matter would potentially remain outstanding or open. So compliance is a very important step. There are responsibilities of decisions within these different stages. Just focusing on the different the stages of the life of a complaint, that's what I'm going to be focusing more on. If you are interested in the actual sections of the decision for the complaints director on how they direct a matter through these processes, those are available within the Health Professions Act, but these are what could be directed by the complaints director, just for context. Next slide, please. So generally, once a complaint is received or submitted, it would be reviewed by the complaints director, the written copy, and then a regulated member would receive a copy of the complaint, redacted, of course, to ensure that confidential or private contact information is removed, but keeping the name of the complainant in the sense that the regulated member would generally know who the complaint, who made the complaint against them, and then contact or an intake or inquiry phase would occur where the complaints director likely would contact the regulated member, and also the complainant to gather potentially more information as relevant, and then make that first decision on what is the appropriate next action for a complaint, and then providing the regulated member and complainant notice or saying this is the decision or this is the direction that is going to be taken. Next slide, please. One of those options is an investigation. If a complaint is being investigated, it may be investigated by a complaints director, or it may be investigated by someone appointed by a complaints director, such as an investigator or an investigative officer. There's different names depending on the circumstances. The purpose of an investigation is to collect information, collect witness statements, potentially collect client charts, client documentation, communication records, etc., other information that may not be available or was maybe not provided with that complaint initially, as well as, like I said, talking to witnesses and collecting their statements and receiving all of their statements through the investigation. Importantly, an investigation is not an assumption of unprofessional conduct, but the purpose is, like I said, to gather and collect information and allowing the regulated member an opportunity to respond to that information in the manner that's appropriate. So such as having their own interview and being able to look at the documents, etc. And then finally, a report is prepared. Part of this process, and I think that it's important for all regulated members to know, are the authorities or the powers that an investigator or the complaints director who is investigating under the Health Professions Act are. It's quite broad in the sense that an investigator under the Health Professions Act has the ability to request documents, to request client charts unredacted, to request someone to give an interview. And that is why, of course, there is that obligation or that definition of unprofessional conduct that if someone doesn't comply, it could also be a finding of unprofessional conduct for someone governed by the Health Professions Act, in the sense that, and just to clarify, because I feel like that wasn't very clear, the investigator has the ability to say, regulated member number 1, you were there, you saw this incident in the hallway, we are requesting an interview of you. And potentially, if there were a failure to cooperate or comply with that request, if made formally by an investigator, that could be classified as the definition of unprofessional conduct. Equally providing documents. So let's say an allegation, and this is an example, an allegation of there's an allegation that documentation has been destroyed by someone, that it's being shredded potentially. This is a very extravagant example. But if someone said, an investigator went knocking on that agency's door and said, hi, I would like to see all your documentation, shredded or unshredded potentially, and this again is a very extravagant example, and that agency said potentially, no, we're not going to give anything up. Of course, independent legal advice can always be sought, but that may interfere with an investigator's powers and ability under the Health Professions Act. Next slide, please. So the next very formal process that is important within this, if it has been determined to be appropriate after an investigation, could be a formal hearing. So a formal hearing would be when that hearing tribunal made up of members of the public, as well as practitioners, are given effectively a list of particulars to say, the example I used before. So on May 31st, 2023, Jane Doe disrespectfully communicated with client 1 about X. That particular or that allegation may be put to the tribunal, and then the regulated member and the complaints director would both have the opportunity to make submissions, present evidence. The witnesses who are called in an investigation may be asked to testify, and ultimately a trial or a trying of the allegation of unprofessional conduct, a determination about whether that conduct occurred, number 1, and whether that conduct was unprofessional conduct, would then occur before the decision maker. There could be a variety of things that are agreed to. So this is getting a little bit into the weeds, but this is all to say that not all hearings are always going to be, every witness must be called, every document must be filed from the investigation. Often it's seen that, there could be agreements on documents or agreement, yes, I did this, I just disagree that it's unprofessional conduct. So yes, I disrespectfully communicated with the member, let's say, and this is unlikely based on the standards of practice, but I disagree that it violated the standards of practice. That could be something that then the argument would only be, or the trial would only be about whether that was unprofessional conduct. In other cases, the complaints director and the regulated member may agree on everything, and they may go to the tribunal and say, tribunal, Jane Doe is prepared to admit that they disrespectfully communicated with client 1 on May 31st, 2023. And we are submitting jointly that is unprofessional conduct, and also this is the appropriate sanction or remediation or penalty for that person. So a hearing doesn't necessarily mean it's a 2-week trial with a bunch of witnesses. That is that possibility, but it also could be a consent hearing, or where people are agreeing to things, but they're being put before the hearing tribunal. And as I said, witnesses could be called to provide evidence. Next slide, please. So resolution is another process available within the Health Professions Act. There are more than one type of resolution, so I'm going to speak about this generally. One type is the type of resolution that requires the consent of the complainant and the regulated member, and there are other potential options available. Generally, it's in the discretion of the complaints director to determine if resolution is first appropriate before potentially canvassing the consent of the parties, as well if it's feasible, etc. A type of resolution then generally would be through a resolution agreement as an example. And what that would look like would be similar to a written contract where it would say Jane Doe, and then similarly the allegation potentially and potentially the penalties. Resolution is a broad tool within the Health Professions Act, and it's difficult to speak in the same way about a hearing. It's not as defined in the Health Professions Act, but it is something that is available and very likely could be offered to a regulated member, either potentially before an investigation, after an investigation, etc. Or alternatively, like I said, in that option, if a matter were to be referred to a hearing, there is still potentially that possibility that a regulated member can demonstrate accountability before the tribunal. So it's very possible that a regulated member will be provided the opportunity to be accountable, or if they are interested in resolving a matter, at potentially multiple stages in the process. I do need to say that there is a caveat for this, where sexual abuse and sexual misconduct are a little bit different in terms of potential resolution, but for the purpose of this presentation, again, we'll put that aside for now, but speaking generally, resolution is available depending on if there is consent and the type of resolution. Next slide, please. So a dismissal. So a dismissal could also be prior to an investigation or after an investigation. And after that report is provided to the complaints director. And a dismissal is generally on 2 grounds, so either insufficient or no evidence of unprofessional conduct, or if a complaint is vexatious or trivial. And that is the dismissal decision of the complaints director. So how practically that may look is the complaints director, depending on what stage it would be, would draft a dismissal or write a dismissal to say, I believe it is insufficient evidence of unprofessional conduct because of X, or I believe this is trivial and vexatious because of Y, and that would be submitted to the complainant and the regulated member as their decision for the dismissal. Going back to that party who was on the screen in the top right-hand side, the complaint review committee, if the complainant, not the regulated member, but if the complainant wishes to seek a review of that dismissal decision, they do have an ability to do so, and that would go to what is called CRC, or the Complaint Review Committee. So this is a little bit distinguishable. Then let's say a regulated member goes to a hearing, a decision is made, and maybe the regulated member wishes to appeal, not the complainant in that case. But if a matter is dismissed, it is the complainant who has that ability to say within 30 days, hi, complaints director or hearings director, I would like to request a review of my dismissal. I believe that the regulated member did commit unprofessional conduct despite the fact the complaints director has dismissed it. I would like you to review the complaints director's reasons, etc. And there are legal thresholds within that process, but just to be mindful that if your matter is dismissed, or if a matter is dismissed, there is still a review process that potentially could follow that process. Next slide, please. So penalties, there's a lot of different ways that penalties can be described. Sanctions is another one, and there's a section in the Health Professions Act Part 4 which describes a large laundry list of potential penalties, sanctions that a hearing tribunal after a hearing could give, such as a caution, reprimand, fine, suspension, counseling, education, supervision in the workplace, restrictions in the workplace. There is a large laundry list. There's no, and then they also have a section, anything that is deemed appropriate. Ultimately, penalties and sanctions based on the law that's available are designed to be applicable to the case before the tribunal, or equally if a resolution offer is being negotiated, potentially to what is being negotiated. They are also sometimes called remediation. So of course, there are some types of penalties that are very remediatively focused. So doing education, improving one's practice, ensuring that they know now what the proper assessment procedure is, or what the documentation standards are, and how much documentation needs to be done, and what that looks like. That is, of course, remediative. So some people will call it remediation, some people will call it sanctions, some people will call it penalty, some people will call it punishment. But ultimately, I would classify it all as the outcome, whether agreed to in a resolution agreement or determined by the tribunal as appropriate. It is the requirements based on the outcome of what is being sought by the regulated member. So like I said, it's individualized, it's fact specific. There are a large laundry list of things available. Of course, on the higher end of the scale, and this is speaking very generally, would be things such as suspensions, etc. Revocation, or removing one's permit and taking it away, of course, is the most extreme outcome that one can have. It's mandatory in cases of sexual abuse, as you all are likely aware, but that is on the very, very high end of the scale. And then, of course, there is a wide range of what could be available. Next slide, please. So we talked a little bit about this earlier, but that compliance phase. So let's say a complaint has been made, it has gone to an investigation, it has gone to a hearing, and the hearing tribunal, based on the section available to them, has said, I want the regulated member, it's appropriate for the regulated member to do X, Y, and Z. Of course, a fine and 3 months of supervision in the workplace, for example, that is outstanding for the regulated member to do. It is the regulated member's responsibility, not the employer's, not their family members, not anybody else's, but the regulated member who has a practice permit, who has been asked to do that, to complete those requirements. And that's, of course, going to the principle that the regulated member or the professional is always responsible for their own practice, for their own conduct, for everything to their college. So it's really their obligation and their responsibility to complete that requirement, whatever it may be, however long it may take. There's some that could, range in years, depending on the severity. There's some that, of course, would be revocation, very rarely, that would look very different. There could be a voluntary exit from practice through something like a permanent undertaking, never to practice again. But again, very case specific. More generally, it would be, you need to do your course. That means you have to go find the course, you have to pay for the course, you have to sign up for the course, you have to complete the course, you have to get the course certificate, and then you have to send that back to the college. So compliance is a very important stage for the process, because what is the point of asking someone to do remediation or a penalty unless it is actually done, and ensuring that that safe, competent, and ethical practice can then be achieved. The complaints director practically monitors the requirements generally, such as, taking action if something isn't completed. This is not to say that this is popular, just speaking generally, of course, but it is important that somebody does get things done and provides it to the complaints director through whatever means they have been asked to do so. Next slide, please. So just as an example, this is an example of a practice permit. So this is what potentially would show on a website if there were potentially requirements outstanding. So as an example, conduct requirement, coursework required, or conduct requirement fine. And generally speaking about a section of the HPA, those would be imposed, or those would be posted for transparency until that requirement is complete. So they would be, if somebody looked up someone's permit, that potentially would show on their permit saying Jane Doe, based on their disrespectful communication, was asked to do a course about ensuring proper communication with patients or clients. That course takes 4 months, or that course takes 2 weeks, however long they're going to take to do it. And potentially that condition will show, or generally that condition will show until that requirement is complete. So it's important to be mindful of that, as well as understand that it is enshrined in the Health Professions Act under a section, and there's mandatory obligations that flow. So if a condition is posted to a regulated member's permit, the college, and any college, has certain obligations such as providing notice of that condition to employers, providing notice of that condition to other provinces, etc. And there are other caveats in the Health Professions Act, but those are the two main ones, generally employers and other provinces. That is based on the Health Professions Act. That goes to the duties and responsibilities of the college and ensuring our mandate as well. Next slide, please. Okay, so looking at publication, recently, maybe not actually recently now, I feel like time is sometimes a little bit elusive, but a few years ago, as you all may be aware, our government passed legislation relating to sexual abuse and sexual misconduct, which required obligations on our college to publish decisions of sexual abuse and sexual misconduct indefinitely. So what that would look like practically is, let's say a member was found guilty of sexual abuse. A decision of the same would be posted to our website, and we have an obligation to do so, to post it indefinitely. Recently, in the amendments to our bylaws, back in the fall of 2020, our council, so our council of the college, passed amending bylaws relating to publication of broader, beyond sexual abuse and sexual misconduct, potentially of decisions of unprofessional conduct, potentially of summaries of resolution agreements, etc. And that is within section 63 and section 64 of our bylaws, which are available on our website. That could potentially include, speaking generally, of a notice for an upcoming hearing, or like I said, a decision of the hearing tribunal outside of sexual abuse or sexual misconduct, or potentially a summary. And next slide, please, Mackenzie. A summary of a resolution agreement that has been agreed to by a regulated member. So going back to my Jane Doe example, so it could potentially say Jane Doe agreed on May 31st, 2023. They communicated with client one in a matter that was disrespectful. They agreed to a communication course, or whatever may be the outcome. Okay, next slide, please. Mindful of time, let's turn a little bit to obligations that it's important that regulated members are aware of. And these are also on our website for review if you wish to do so. The main one being on employers. So often, and this is pursuant to Section 57 of the Health Professions Act, sometimes the question says, well, they were a contractor, they were part-time, they were a consultant, or even if they were a volunteer, it's not employment. So it's important for regulated members to know, especially if in a position of employment or contracting to another regulated professional, that employment is defined as being engaged to provide professional services on a full-time or part-time basis as a paid or unpaid employee, consultant, contractor, or volunteer. So that is a definition within the Health Professions Act. The reason why this definition is important is that looking at the second paragraph on this slide, if due to conduct that is in the opinion of the employer is unprofessional conduct, a regulated member is terminated, suspended, or they resign, it must be reported to the college as soon as reasonably possible. So of course, there are specific union requirements regarding letters of suspension and grievances and letters of warning. I'm not going to get into that, and that's not my area of expertise. But as an example, speaking broadly, let's say there is an agency and they have a staff SLP on their staff, and the owner of the agency is an SLP as well, and their employee or their contractor SLP either resigns based on an incident that they believe is unprofessional conduct, or they're terminated based on an incident that the employer SLP believes is unprofessional conduct, there is an obligation within the Health Professions Act that has a consequence of a fine if not abided by. But it's important that anybody who is in a position of employment as defined by the Health Professions Act is aware of this obligation to then report to ACSLPA in the complaints process about that concern that resulted in termination, suspension, etc. Next slide, please. Turning, of course, to more obligations relating to the complaints process, there are equal obligations on regulated members for mandatory reporting. So I think we can start with the most straightforward one relating to sexual abuse and sexual misconduct. There are mandatory obligations relating to reporting allegations or concerns of sexual abuse or sexual misconduct within the Health Professions Act. There is a caveat to that drafted within The most frequent example that I give is a little bit outside of this context, but let's say an SLP is receiving their own private psychology services and discloses potentially something. There is an exception that if it's in the provision of services that they're receiving, therapeutic services, it's a little bit different versus the example that would generally trigger this requirement is, you know, an SLP working in a hospital setting on the unit, walks into a room and observes something or hears of something or, you know, is disclosed of something that is sexual abuse and sexual misconduct. There is a mandatory obligation that could be triggered, equally, of course, for employers or managers, etc. But there is a therapeutic exception in the Health Professions Act. And of course, if you are interested, I encourage you to go read that. But there is an obligation relating to sexual abuse and sexual misconduct. Equally, there are obligations on a regulated member to the registrar. So this is a little bit outside of the complaints context, but relates in the sense of their own practice. So there is something called self-reporting. So high registrar or high complaints director on, you know, for the last 3 months, I have been doing X, or this incident occurred with the patient, or, you know, something happened. I am reporting it to the college based on my obligation, as well as, of course, professional negligence findings relating to civil suits or criminal charges or convictions. So high registrar, I've been convicted of a criminal charge, or I've been charged with this criminal charge. There are different obligations, and there is a form, I believe it's still available on our website relating to that, and I encourage you to go look at it if you've never seen it before. Equally, a regulated member also has obligations about concerning behavior of other regulated members. So our standards of practice do have sections that speak to this regarding incompetent or unethical services. And generally, there are professional obligations relating to if an SLP or an audiologist has concerns about another member, or they believe they need to report someone based on incompetent or unethical services, etc. There's also a section within our standards of practice that say within reporting concerns regarding the conduct to do so in an open, fair, respectful manner, including consultation with the service provider to ensure one has relevant facts. So just to be aware and mindful of that obligation in and outside of sexual abuse and sexual misconduct, putting that aside, but also to be aware of our standards of practice and bringing concerns to a college. Or any college, it could be another health practitioner, etc. Next slide, please. So I spoke about this a little bit earlier, but it's important to remain in contact and comply with the college. There are definitions within the Health Professions Act regarding obligations to comply. So we use the example of complying with an investigator or complying with continuing competence programs. And it also broader, just ensuring that responding to the college and ensuring that you comply with requests potentially. There are obligations defined within the HPA. Another really important one that is a little bit less frequent, but it relates to the complaint process and is an obligation to ensure contact information is up to date. So regulated health professionals are required under regulation to keep their contact information, their business addresses, their personal addresses, their phone numbers updated to ensure that their regulatory body, the college, can contact them where necessary when required. Part of that could be in the complaints process. So an example could be potentially that if none of that information is up to date and the college receives a complaint, it's very difficult to provide a complaint to a regulated member if none of their contact information is up to date. Equally, of course, it relates to colleges' obligations to keep their registrar updated and ensuring that we have all the information of our regulated professionals. But there is a responsibility. So of course, regulated members have access to update that information on our website through, I believe, and portal is the incorrect word, but their membership page or their registration page, and allowing them to update that information on a regular basis. So if they switch jobs, if they move, if they change their phone numbers, if they want to put in a different email address, adding it to kind of a list of when you move, what do you need to update type of thing. Next slide, please. Okay. So going to a little bit to rights and obligations, we talked about how the Health Professions Act is a guidebook. And part of that guidebook is there's certain rights or certain procedural fairness rights that are generally enshrined in the Health Professions Act. So one of those could be the right to know the allegations against you. So how that would be practically conducted would, like I said, the regulated member would then receive a copy of the complaint to know what they're being said is unprofessional conduct, what's being alleged against them. Another one could be a right to respond. So going to the example of an investigation, allowing a regulated member to give their own interview and respond to what has been raised about them. Looking at the patient chart and say, yes, I remember that, but this is what actually, this is my version of events. So that could be another part of the procedural fairness or the rights that's enshrined in the Health Professions Act. Of course, the right to have a hearing, we've discussed that. The right to appeal, we've discussed that as well. And the unbiased decision maker. So going back to the beginning of the presentation, when I said, as a complaints director, I would not be on the hearing tribunal. I would be before the tribunal and, advocating for a finding of unprofessional conduct, but I would not be that decision maker, of course. So there are protections in the Health Professions Act to ensure that a regulated member doesn't have a biased decision maker, doesn't have the complaints director being on the hearing tribunal, etc. And then, of course, right to counsel. Speaking more broadly, it's encouraged, and it's in our website, that if a regulated member wishes to seek legal advice, if they wish to seek assistance from a representative, an agent, counsel, etc., they're entitled to do so. They can come to the hearing with them, etc. And that's up to the regulated member. But this is all to say that there are procedural fairness or rights for a regulated member facing a process of unprofessional conduct, facing a complaint of unprofessional conduct, built into the Health Professions Act, as well as just general principles. This is, and just as kind of a more background on this, and I also know I have a few extra minutes. So this concept of procedural fairness goes to, if the process isn't fair, it may affect how fair the decision is. So this isn't necessarily, the decision of unprofessional conduct was right or wrong, but was this process fair throughout, was the regulated member provided that opportunity to respond? Did they receive the allegations against them? Were they made aware of the date, time, and location of a hearing? This is I think a straightforward example, but it's very hard to go to your hearing if you don't know when or where it is. So part of that obligation that's triggered, it would be in the Health Professions Act. It says a regulated member must be made aware of the date, time, location, and a hearing. Same with the complainant, so they can know where to go and when to show up and when to defend themselves potentially against this allegation of unprofessional conduct. That is to say, if they did not know that, how could the decision be fair? So this is why, again, going back to contact information and ensuring that, we're able to stay in touch with you. These are all interrelated concepts to say this is a formal process. There are rights, there are obligations, and there are steps in the HPA, or the Health Professions Act, that the college is following and the regulated member is following and everybody is following, but they're all really going to the fairness generally of the process on this slide. Okay, next slide. So I know I have about 8 minutes left. I do have 2 examples. I'm not too sure of the interactive nature of this platform. So what I think I'm going to do to assist the audience is I'm going to read out the first one. And if anybody wishes to respond by putting something in the chat, of course, we can talk about it equally. If anybody has any questions for me that I can attempt to answer within the boundaries that I feel comfortable with, I'm also happy to do that. And then I think, depending on the time, I also can introduce the second one. But let's go to the first one, please, Mackenzie. Okay, so Jean is a speech language pathologist who does not know much about their college. They only renew once a year, do required continuing competence, and otherwise do not engage with the college. One day they receive an email from someone named complaints director requesting that they be a witness to an incident that happened in their work setting, a hospital unit. The complaints director indicated that they are investigating a complaint. Jean recalls that their colleague had an argument with the patient while they were nearby in the hall that they could partially hear. They are also worried about their friendship with their colleague. So what are Jean's rights and responsibilities that we discussed today on general information about our complaints process that relate to this request to Jean? And if anybody is able to answer or wishes to answer, please feel free to do so. And Mackenzie, just to confirm, are the members of the audience able to put things in the chat?
Yes, the chat should be open to everyone who's in the meeting today.
Well, I will give it a few more seconds of staring in silence, and then I will definitely answer it myself. I think we've reviewed these concepts, but if anybody does wish to participate, feel free to do so. So as we discussed, this is going to the obligation to potentially comply with an investigator's request, who in this case is the complaints director themselves. What I would say, and again, this is not legal advice, but a regulated member is entitled to seek their own advice if they wish or feel comfortable to do so, or the counsel of a representative. But based on the Health Professions Act, the investigator or the complaints director has a broad authority to request people to answer questions or give interviews or provide documents. So potentially, another example of this could be, what if it was recorded on a cell phone? Or what if there is a Instagram live, Facebook live video of it? Those are other examples that could potentially be requested of Jean. I don't, and I would hope that nobody is recording in a hospital unit of their colleagues. But just as an example, and hopefully an example that does not occur, that could potentially be requested of them. Turning to the next slide. Thank you, Mackenzie. So this is a second example. So Deidre owns a private audiology clinic where there are a mix of staff, so 2 SLPs, 3 hearing aid practitioners, etc. And they are contractors, the SLPs, or speech language pathologists. They do not work in the office, and they attend to clients virtually or in clients' homes. They do not receive benefits, and Deidre does not consider them to be employees. One day, a concern is brought forward by an adult client about an SLP, Mark, acting inappropriately, specifically that they complimented a client's appearance multiple times, asked them if they liked him, and asked for the client's Instagram so they could see more photos of a client when they were not together. Deidre spoke to the SLP, and the client, based on the information collected, determined that she would end the contract immediately. The SLP disputed the allegation and has now hired a lawyer to sue Deidre over an employment or contract dispute. What is Deidre's responsibility to report Mark to their college? So we also discussed this. I'll give it a minute for the chat, but I anticipate after a minute or so, I will answer this one as well. So, of course, this is relating to obligations of mandatory reporting for sexual abuse and sexual misconduct that potentially could fall under the definition of sexual misconduct. There is information on that broad definition within our standards of practice and, like I said, on our website. But, putting aside if this was not sexual misconduct and maybe just an incident that happened outside of commenting on physical appearance or asking for Instagram or boundary violations, there is still that definition under Section 57 of the Health Professions Act that they're a contractor and they were terminated or their contracted ends. So there may be that obligation on Deidre to report to the college under Section 57 of the Health Professions Act. So it's important to keep that in mind, like I said, for regulated members in a position where they have other contractors or they have other staff. So with that, I know I have about 3 minutes left. I'm happy to review questions if anybody has any. And other than that, thank you so much for joining us today. I hope that this assisted in general information on the complaints process. I encourage everybody to review our website content under complaints and concerns about how to make a complaint, the complaint process in more detail, the FAQs I mentioned, or potentially the other pages that are on our website, such as our annual reports with statistics about complaints, our bylaws, or other standards of practice that are relevant and you wish to review. And thank you so much for your time and attention today and sharing your lunch hour with us. I will wait for the next couple of minutes if anybody does have any questions. Mackenzie, I don't see any questions, so I'm going to pop off, but let me know if anything arises. Thank you.